Always so much to talk about. And without further ado, the time now is 8:30. We got about an hour and 23 minutes left, and we're going to go to our first guest, Chris Lindsey. Chris, of course, is a legislative analyst for the Marijuana Policy Project and Michigan's MPP liaison. He was in Montana for a period of time, which, of course, invokes images of Jerry Spence kind of suede jacket with ruffles on it. Maybe he'll tell us we're wrong, or maybe he's wearing a special jacket tonight. But without further ado, Chris Lindsey, joining Planet Green Juice. Thanks for being here tonight.
Yeah, hey, thanks very much for inviting me. So, and I actually am still in Montana, so yeah.
Yeah, that's what I was going to say. I know. I was going to ask you if you liked the Michigan politics or the state, compared to Montana. But but Montana's gone through quite a lot of significant changes. Not all good. Would you explain a little bit of the history of where Montana's law was in relationship to Michigan's, and what the MPP's thoughts on those types of initiatives at that time were, and then what happened in Montana since then?
Okay, well, Montana, like a lot of states during that period, was a voter initiative state. So, like Michigan, I believe, now I'm saying it, I'm not so sure, but I believe Michigan's law also came in through a voter initiative.
Correct.
Is that right? Okay.
Yeah.
So, the Montana law came in 2004. Really sort of flew beneath the radar through the campaign. Not a lot of people were even aware it was there, which I think was to its benefit, because there wasn't really a concerted effort to oppose it. And so the law came in. Growth was steady but slow, and it was really, like a lot of places around the country, put on notice during Obama's first presidential campaign that he was going to take a different tack, and started making the statements about, well, we're not going to, I don't think it makes sense to put law enforcement resources on the federal level towards enforcing federal laws. The states adopt their own laws, and so a lot of people, of course, were paying close attention to that, including me. And I, during that time, since about 2004, I was a trial attorney in Montana doing both civil cases and criminal, but not specific to marijuana during that time. I started getting involved in 2006 when I was diagnosed with Crohn's disease, and despite having a doctor who told me that he thought that my then recreational use of marijuana actually helped alleviate the symptoms of my condition in such a way that I was really self-medicating without realizing it. So it made it really tough for them to diagnose my condition, because I was a lot older when my symptoms showed up than most people who get the disease. So anyway, the doctor said, when you get out of the hospital, you might consider continuing to consume. And, of course, I did get out, obviously, and went back to him and said, hey, you know what, I've got a family at home. I was the managing attorney in the state capitol in the public defender's office. I can't be on the front page of the paper getting busted for marijuana. So, hey, sign my recommendation, and he wouldn't do it. And that kind of set me off, because I said, look, there's no question that I have a qualifying condition. There's no question that my treating physician thinks that it helps. So what's the problem here? And so that kind of put me on a certain track. And I got involved in politics at that point. And so by that time, the next legislative session was really the one that I started getting involved in. And so we saw where the danger was. And the danger was that the 2004 law was really vague, and it was vague on purpose because MPP at the time that it provided the language, its strategy was, let's put down the bare bones, let the states flesh out the details. Let's not get too specific because it's gonna paint things in a corner. The problem that we ran into in Montana was the legislature did not like the law. They didn't want to deal with it. It was really taboo, and so they never went in and put in a regulatory system. There were vague references to caregivers, no limits on patient numbers, unlike in Michigan, no limit on income potential, but no clear regulatory framework for business. And so we did our best to convince the legislature that it needed to step up, because by the time the Ogden memo came out in October of 2009, it was clear what the standard was, and I'm sure everybody in here knows that it was clear and unambiguous compliance with state law. Well, if you've got a vague state law, you can't be in clear and unambiguous compliance with it. So we were concerned, and the legislature once again refused. They had 4 opportunities to amend the law, refused every time. So it was during the summer, starting really in the spring, getting into the summer of 2009, that we saw patient numbers skyrocket in Montana. I mean, if you look at the graph, it has that hockey stick shape, where it's sort of gradual and everybody's happily bumping along, and it sort of increases a few percentage points every year, and then all of a sudden, just went ballistic through the top of the chart. It went from something like 2,500 patients to nearly 30,000 in a year. And that was just mind-boggling. And it completely changed what was going on in Montana. So, early 2009, you talk to people in Montana generally, hey, you know what, marijuana, if it helps people, I got no problem with it. And that it didn't matter if you're talking to a legislator, talking to a cop, talking to a grandma, soccer mom, everybody had the same answer. And I actually decided, along with some other people that I had a lot of respect for, that, we need to have businesses involved that really take this very seriously, do everything they possibly can to set a good standard, and let's get involved. And so I helped form a business that became one of the biggest ones, although compared with other states, it's laughably small, but in Montana it was kind of a big deal. And got in the press a lot. We used to give tours to just about anybody, including law enforcement. And our hope was to set a standard. And I think it was naive, and it sure sounds arrogant to say it, but, that was the idea, that we were going to have stuff tested, which was kind of a new deal, especially in Montana at that time. Testing labs were just getting started. We wanted to do the tours. We had open conversations with drug task force officers, with county attorneys, with legislators. We documented things. That was like kind of where things were at the time. That was actually a kind of an innovative idea. And so, we thought we had it going on. And our goal was to then go back to the legislature during the next session and say, hey, we've been there. We know what you need to do if you want to get a handle on this stuff, and then make recommendations. Well, partnerships are kind of hard to manage sometimes, and there started to be some friction amongst the partners, and at a certain point, I left the organization, and that was just short of a year. So I left we started in April 2009, really going, with plants in a greenhouse in an enormous facility in the state capital. And I was out by January of the next year, and by that time, I kind of figured, look, we got enough people growing marijuana in the state. We need to have attorneys that can help, address some of these problems. And so I became a full-time medical marijuana attorney, and picked up a lot of clients. I represented patients, caregivers, doctors, folks working in testing labs. Kind of got involved in all the aspects there. And it was about that time that the atmosphere in the state really started to change. We started seeing pushback. So where before it was, you know what, it helps people, we're libertarians, it's fine. It really, really went, it flip-flopped to, good God, this is out of control. And
let me ask you, was it because of? Can you pinpoint? Because I'm a lawyer as well, and the way you kind of described the practice, getting back into it, in the moment of, the chaos and being a lawyer and all that. I mean, it's terrible to see what's going on around the people. It's exciting from a lawyer's perspective because it's new law and you have things to fight for. The law's new and it's a tool now that you can utilize and actually make an impact in some capacities. And but beyond that, when you were changing from that perspective of as a caregiver back to a lawyer, was it an easy transition? I mean, was there did you have a easy time dropping back in as a lawyer and representing clients and patients and caregivers?
Well, I really enjoy brainstorming, helping people figure out how to approach things, sharing experience. I liked being an attorney that actually knew the subject matter, because most lawyers that get involved, this is taboo stuff, and they spend a lot of time saying they don't really know. And, I knew this stuff backwards and forwards because I had lived in the greenhouse growing marijuana, 24/7, had dealt directly with patients, and came to really understand, as a patient myself, but also what it means to be a caregiver. It's not like being a black market grower or distributor where, look, you know what, this is what I got. I harvested it, you take it or leave it. If I don't have anything to sell, you go talk to the next guy. But when you're a caregiver, you develop a personal relationship with the person who you're providing a drug that transforms their life. And that is a huge responsibility that you don't necessarily think of before you head down this path. So I was acutely aware of how seriously my clients were taking this, how much it meant to them, how much people relied on their work. So in terms of the transition, though, it was a huge shift. So while I kind of got a charge out of, hey, I'm the guy that understands your pain, it was a huge responsibility because lawyers like rules. I sort of call it, it's like they're the vines from which we swing, right? Tell me what the rule is, and I'll tell you where you stand. That's the nature of legal advice. But when you're in an environment in which the rules are vague, it's a very, very tough place to be because people come to you, they want answers. Look, can I do this?
Yep.
And you're left saying, well, I think so. Here's the issue. Here's this part of the law that says this. And that sure sounds like yes. The answer is yes. But then you look over here, there's this part that says maybe not. And so I was constantly worried. I'm pretty risk tolerant. I jump out of airplanes for fun. I'll do things and stick my neck out. And I knew living in the greenhouse, 30 feet from the highway, that we could get robbed. And that was part of what I was willing to do. I knew that the Fed could raid us. I knew that the state may decide one day that they didn't like something we were doing. And that's one thing, to stick my own neck out. But when I have people that are coming to me saying, help me make sure I do this right, that's a much different feeling. And so the pressure was a lot greater when I made that transition back into practice. And it seems like it would be easier, right? Because I'm not having to move plants twice a day in and out of the light depth tent, all that stuff. And
you did say you were living in the greenhouse, right? It was a full-out transformation.
Sweet.
Right?
Yeah, it's called the State Nursery. It's a facility that had been around since the 80s. It was enormous. And it was available to us, just fell right out of the sky into our lap. We got really lucky. We got a sweet deal on rent and had just overnight 18,000 square foot facility that was designed for the production of plants. I mean, everything was there. It was old, and we had a steep learning curve in terms of weatherizing the place and kind of bringing it up. But it was amazing. It really was. It was an incredible experience. For those who've seen a movie, go ahead, sorry.
What was the movie? Go ahead.
There's a movie that Rebecca Richmond Cohen put together called Code of the West.
Oh, yeah.
And it talks about the Montana story, and that business, Montana Cannabis, is actually the business that I was involved in. I had actually been out of it for 14 months by the time the Fed later raided. That's a whole nother story, which we might get to if you want to go there. But
no, I do.
The bottom line, well, so we had this amazing facility, and everything was awesome, and we grew too fast, which is, I think, an easy place to be in this business, because you've got people coming in the front door. They want your help. You believe in your product. You believe that you're doing it right, and you don't want to say no. And unfortunately, I think we took on too many people. People who aren't in the business don't realize often that there's this lag time. And while I'm an attorney, I don't know the nuances of Michigan's law, and I'll defer to you, Michael, but in Montana, the day your patient is authorized to be in possession of marijuana is the day that you're authorized to plant a seed or, cut a clone. And so you've got 3.5 months at best before you're able to serve that patient. And that puts you in a really tough spot, because your client's like, hey, I'm here, here's my card. And you get to explain to them, okay, come back in the spring, And that's hard. And so, you're sort of robbing Peter to pay Paul, and can you do that if these plants belong to another patient? That's not clear in the law. I know Michigan's dealing with that problem, because I was talking with Jamie about this earlier today about, the moment that you cut that plant down, what does that count towards? Is that you wouldn't count that towards your gross number of plants, but does that count as weight against your 2.5 ounces? And so
we're not. That's the Carruthers opinion addressing really for the first time the concept of usable material. Michigan law, and we can I have so many questions I want to ask you. It's very fascinating, because I know the closeness and proximity and some of the significant. There's a significant political moments that happened along the way in Montana that obviously changed things. And right at the crux of your story, so I don't want to lose the timeline. But the reasons for the change of the legislature or them hating the law, and something that you referred to earlier, which was that it was. You said vague, that the Montana law was written vague. And I didn't know that you were going to even use or go there with that. But when I was talking earlier, when I called my rant, I was discussing how I believe I was going to ask you, the Michigan Medical Marijuana Act, or the MPP's position at the time was one of writing with a broader stroke, because they didn't know where things were going to go. And also it's challenging to write something simple that everyone can agree upon that's actually going to cover specifics, and it's better that, in the medical usage and different ways in which it was going to be ingested were, unknown at that time. So why I write something restrictive? Instead write it with broadness. And I always say that the problem is that the law is not a poorly written law. It's written intended to be broadly. It's the people that are reading that don't want to see it that way that say it's confusing and badly written. The opponents of it. But those are those. That's a law enforcement community that's looking for what you can do and what you can't do, and anything that's not on one of those, on the list that you can do is ambiguous, and thus, we're going to debate it not here, but in the court, and we're going to take you in, and that's one of the things that, I've talked with other lawyers about it, about giving advice in uncertain times. You know what I mean? It's very challenging. The concerns that you have and the responsibility that you mentioned of, people that are relying upon you. I mean, even no matter how much of a risk taker you may be or how forward thinking and how you want to interpret the act, you still got, you still have the concerns of, liabilities and safeties, the safety versus, risk. I think, and that's what it is. I mean, there's no easy answers. It's always a assessment of what your risk is in this current situation. But, all right, with that being said, I meant to ask this question earlier. You were right about that timeline. I think it was 2009 after the Holder memo. Maybe it was the year after. It would have been 2010 when the Montana law was like terribly legislated away, right? And then there was some others. What I want to ask you is, can you identify right now what brought that about? What took a libertarian community that, to there's something really wrong here that we have to get behind being very restricted? Because Michigan at some point may have been, and I think we were really in that position. Our Attorney General was leading that charge, and I think his acting like a judge, an Attorney General, and a legislature made the Supreme Court that would never agree on anything ever come together and rule, in a way that was really with the initiative and almost like an opposition of territory and power, almost like a Marbury versus Madison. Like we're the judicial branch, no more force and threat and powering these other two branches. I don't know. Maybe that's my whole fantasy about that. But tell me what your observations were at that time that pushed the political structure in that direction.
Yeah, and I can pinpoint it probably down to the actual days when certain things happened. So the first thing that really happened that started to turn the public away from its tolerance of this growing industry was a clinic that got set up, patterned after and badly patterned after the Hemp and Cannabis Foundation. Paul Stanford would periodically visit Montana, and what he would do in all the states where his clinics would start, and don't get me wrong, Paul had nothing to do with how things went off the rails, but he gave an entrepreneur some ideas. So Paul's plan was to come in, find a temporary location that would work for a day or two during the month, and visit, a certain number of patients, and it was a very modest number. And I think his idea, I'm supposing, is that once he sort of reached a critical mass, he'd open an office. Well, there was a person who started trying to work his way into those clinics and started bringing large numbers of patients. And Paul's organization is really tight and well considered. And, you set up in advance, send your paperwork in, their doctor will look at it well before the day, and then that same doctor will come and meet him in person and kind of corroborate what they see. And so there's a good bona fide physician-patient relationship there, which is important. Well, this person basically created a assembly line approach and started signing up people over these weekend events that would run all day, for 3 or 4 days, and sign up hundreds and hundreds and hundreds of people. And so that was, others were doing, other clinics were opening, but that one was the one that started to get all of the attention. And he was a media hound. He loved having cameras there. And his strategy was very much in your face. He would go to events like rodeos in, rural parts of the state that really are not liberal by any stretch of the imagination, and sit in the stands with families all around, and he'd pull out a pipe and just start smoking. And then law enforcement show up, and they'd tell him to put it out, and he'd just start getting in their face about how he has a right, he's a patient. And then as the crowd would form, he'd start passing out cards. Hey, come to my clinic, get your card. And that kind of stuff really started to work against him, because what happens is all the law enforcement guys in our state know each other. So they'd say, hey, I'm over here in, this town, and they'd start calling other, or said, do you know who this guy is? What's the deal? And so word of mouth started to spread about this particular outfit. And the press started following it around. And a lot of the papers in our state are owned by the same publishing company called Lee Enterprises. And so if a story ran in one paper, it hit all the other papers. And, there's really only about 9 largish cities in Montana, so it doesn't take much to reach most of the population. And so, you get a picture of a bunch of apparently healthy people, and, of course, I'm well aware of the fact that there are very sick people that look healthy, including me, by the way. But the image really did not play well of what appeared to be very young people, appeared to be very healthy people, smoking marijuana in public in a park. And they're hanging out waiting for their turn to see the doctor across the street. And so Montanans who were before saying, look, I'm fine with this working for somebody who's sick, that was not what they wanted to be seeing. So that was really where things started to look very awkward. Where things went off the rails was when that same individual started going to legislative sessions and hearings, and there was a couple of famous images where he went outside and was standing on the steps of the Capitol and pulled out, it must have been a 2-foot Gandalf pipe, and just fired it up. And that ran across the front page of most of the papers in the state, and it went on the press. He would say in wildly unhelpful things in hearings about how rich he got. I'm a millionaire, and I've only been at this for a year. And it wasn't true. But the impression was, this is a bunch of greedy young people who don't have medical conditions, who are just getting their cards so they can smoke pot and blow it in cops' faces. This is BS. And then I would say that the sort of the third leg to the stool here was, we've now got 30,000 patients. Somebody has to provide to them. And so following this explosion in patients, we saw, the second line on this graph track up quickly, and that was providers now proliferating. And, these weren't guys, renting out doctors' offices or office complexes. There were storefronts with big signs, billboards, get the cheapest ounce in Billings. It was the advertising which I think pushed people right off the edge. Because, when you've got the U.S. Attorney for Montana driving to work every morning past a billboard about the cheapest ounce in town, you're pissing that guy off pretty bad. Yeah. And that's when law enforcement, the first thing that happened was law enforcement just called bullshit. And so before, we're fine. we had a good relationship with them. We started getting sort of hints like, look, guys, you might want to think about another line of work here. And I unfortunately wasn't smart enough to figure out what they were talking about. But nonetheless, law enforcement stopped taking calls, didn't want to do tours. County attorneys would no longer, consider, hey, here's my business plan, what do you think? You couldn't have those conversations anymore. So that's about the fall of 2009. And by the time we're into 2010, things are pretty frosty. And so that 2010 was really a pretty ugly year because we still had lots of people involved, lots of businesses, money is starting to show up, some people are starting to drive BMWs and stuff, and it's like, And leading into that next legislative session following that, the legislature was basically, their position was, this is broken. It's so broken, we can't fix it. And we were in, a lot of the activists, the core activists were saying, look, please regulate. Here, we will work with you. Tell us what you want. We will help make it happen. And they basically said, look, you guys are the problem. We don't care what you have to say. We are going to take you out. And so the first thing they did was repeal the law and just say, we're done. There's no more medical in Montana. Forget it. And fortunately, the governor vetoed the law. It's the only thing that kept that from happening. And so in the closing days of that session, because, these idiots didn't give themselves enough time, they had to cobble together a quote-unquote regulatory bill. And so because the leadership had promised their constituents that they were going to get repeal, even though it was a voter initiative that put it on the books, they technically repealed the 2004 law and instituted a 2011 law that effectively said, yeah, you can be a caregiver, but you can only have 2 patients, and a caregiver cannot receive anything of value. And you couldn't do things like, okay, I'm going to charge you $30 for the bag. I mean, there was no chance really to make that function. And so the next thing that really happened was I had helped form one group called the Montana Medical Growers Association, the MMGA, and it was a good group, but I think it was formed when cops still didn't have a problem with what we did, and once that changed, the MMGA really kind of lost its footing. Like, how do we deal with this now that we can't just sort of have dialogues with people anymore? So by the time that law passed, another group formed that I also got to be a part of, and called the Montana Cannabis Industry Association, and it was a lot more aggressive. And so it initiated a lawsuit to try to block the law. And we hired an outstanding attorney who's still working this case, still doing a great job. And basically it was a constitutional challenge to say the state can't, with one hand, tell people that they have a constitutional right to health, and with the other hand say, but there's no way for them to have access. Because to say that a caregiver can provide but can't receive anything of value is basically saying they can't exist. You can't pay for lights, you can't recoup costs, there's no critical mass, you don't get more than 2 patients, and even those, it's free. It's ridiculous. It's
a very important issue, because I still think like there's nothing in Michigan that says it's got to be for-profit or not-for-profit. Some people think, California is the way, and that's the way they did in California, so that's how we're going to do it. And Colorado did it in a more, for-profit. And, one of those two has been more accepted, I think, arguably, as a better regulated, revenue-producing, symbiotic with the government than the other one. But here's a question I want to ask you. We don't have a lot of time. I feel like I could talk to you all night, and I feel like we're just at the tip of the iceberg of this history development. There's so much more to talk about. But one of the, because everything you're saying, I think we've been right on the edge, hanging on for dear life.
Sure sounds like us.
Yeah.
We may be over the edge.
But anyways, it brings us to this next topic, which we just suffered a huge setback on the issue of what is called edibles, or an individual who is possessing a food product or some extraction for that matter.
Right.
And the Court of Appeals essentially said that, a lot of terrible things, but because it cannot be measured as to the quantity of THC, even though we can detect it under current state lab, usage, because we can't determine how much we have to ban it all. And anything that's not part of, the definition of usable material, which is the dried bud or flower of the plant, anything that's not that, anything that's more than up to 2.5 ounces of that is not material that one can possess. That it's something else. So, like you gave that example, if somebody cuts their plant down, what is it? It's not a plant. It doesn't have roots. It's hanging. It's definitely not dried bud. It falls into the other category of marijuana. It's a really bad opinion. Me and two other lawyers are actually, we filed the application. It was either today or tomorrow to the Supreme Court. It's a terrible opinion, but it comes back to the question of this, which is a more difficult query. What is the workable way to do it? Right now, they say, the police or the court says, because we can't measure the levels of THC, they actually say the unmeasurable, highly potent brownies. They say the unmeasurable, highly potent. This is not, they can't measure it. How can it be highly potent? But the perception is, in this opinion, that it's dangerous, even though they don't know even what that means, and there's no basis for it. But so they say we can't measure, therefore it's all, gone. What is a workable way, moving forward where, and I'm not talking about just good for the patients, even though talking, one that would be acceptable to law enforcement. That's kind of the challenge on this issue.
Yeah, and okay, so I'll just put it in my own terms, just so I can kind of, start out that way. And so the issue here is the disconnect between the definition of quote-unquote usable marijuana that appears in the Medical Marijuana Act and marijuana, which appears in the health, basically in the health code. And I can tell you what the problem is, and I'll just give you a quick explanation of how we ended up with this problem. The problem is that the definition of usable marijuana is much narrower than the definition of marijuana. And while that seems kind of silly to be throwing those terms around and act like they're different, it's a big deal. And that's where the appellate court spent a lot of time in its analysis. I watched Montana Supreme Court go through the same process. Arizona's agency just went through it. So this is a trend that's happening in other locations. And the problem is within the usable marijuana definition, it's flowers, it's leaves. When you talk about marijuana in the health code or in the criminal codes of other states, it's the entire plant, living or not, any extraction from that plant. It's everything except for stalks, sterile seeds, and extractions from stalks or sterile seeds, as long as there's no THC in either one of those things. So it's where the marijuana definition casts the broadest possible net. Usable marijuana is much, much narrower, and that's where you run into problems because, hey, we're talking about an extraction here. Okay, well, so the appellate court in Michigan, Supreme Court in Montana, and the agency in Arizona look at these two definitions and they say, well, usable marijuana doesn't talk about resin. I don't see anything about extractions, but I look at this definition over in the other part of the law, and sure as hell there it is. Okay, so if you're and you're an attorney, you know where I'm coming from on this. When you're interpreting statutory language, there are rules about how you read things and what they mean. Where the comma is makes all the difference. Does it say and or? And what one of the rules is, if something appears in one definition and doesn't appear in another definition, there's a reason. It didn't happen on accident. And courts cannot just read things in and say, well, that's the way it works. So it meant a lot to the appellate court in Michigan that resins and extractions did not appear in usable marijuana, but did appear in marijuana. And one thing that I would share with all of my clients, I'm trying not to spend too much time on this because I know time's short, but it's very useful to look at the Marijuana Act as an exception to the criminal law. So it's tempting to look at this as, hey, there's this law and it stands alone. The problem is that the way courts often interpret it, and I'm 99% sure this is the way Michigan courts do this because of the way the law was, this decision was rendered, is by default this is all illegal. Growing plants, selling plants, possession. All of it's illegal. The only reason why it's not sending people to jail is because of these exceptions carved out by this Medical Marijuana Act. And that puts people that operate in the medical marijuana arena in an incredibly risky position, because it means that, hey, if you step outside these definitions of what you're supposed to do, you're in not only criminal territory, but probably felony territory, because there aren't very many crimes associated with marijuana that aren't in felony territory. And also, I would add, I mean, you're right on in terms of the exact way that despite my interpretation otherwise, that is the way that the Supreme Court has ultimately ruled. There's a exemption or immunity provision that's a strict statutory limitation. If you step outside of it in any way, you're subject to arrest. It's considered just like the specific prohibitions. The charges come out of the Public Health Code. But the one good thing in Michigan right now is that they did expand the affirmative defense and allow cases to proceed to in front of a jury at with a certain threshold, and that was one of the core elements of the underlying initiative. But we do have to wrap it up. But finish your thoughts on the existence of the laws it is right now, as you're talking about. Okay, so where do we go from here? Sorry, it took me a while to get there. So there's two approaches. There is change the law. There is litigate it and get case law back in line. You've got bad law out there on the appellate court level, so you're going to either have to fix it at the Supreme Court level, which is going to require some fancy footwork and going back to the intent of the voters and making arguments that are hard to make. I can tell you it's a whole other story, but I've been there on a different issue in Montana's courts, and the Supreme Court completely shut me down, despite all of the rationality and logic behind the argument. So I'm skeptical. I respect the work that you're doing. I just have to say, from my own perspective, that is a difficult row to hoe. And the other way is change the law, and that's where it needs to be. It's not a hard sell. Edibles are preferred by physicians. They are better in many respects for a lot of patients. And to the comments that you made before I jumped on, but I heard you say some people, you get a different medicinal effect from edibles. And to say in Michigan that the only way you can consume your medicine is to smoke it or vape it is ridiculous. So
that's what I was going to say. If you polled, from a national organization, if you polled people who have voted in these 20 states, do you think the only way that patients, these people that you're envisioning, whomever they are, when you pulled the ballot, whether they were whatever that person was in your mind, are you saying the only way they'd be able to ingest would be smoking, or do you think...
Or to eat flour and leaf. Which
is not really a thing. People don't think like that, Mm-hmm. But I'm just saying if there's other... And the other question is this. you may be right, because the issue may be that those arguments to the Supreme Court that the voters did not intend for the only method of ingestion to be justices to be smoking or vape. What about these kids? What about these children whose parents now are subject to, arrest because they're possessing a brownie? I mean, come on. And they may say that's not our problem. Go to the legislature.
That's what I was told. I did a argument that was similar to another case in Michigan on caregiver, what we call caregiver to caregiver, and it's a whole other discussion. Unfortunately, we won't have time to talk about it. But the bottom line was, I had a lot of solid arguments. I felt very strongly in my opinion on this, and went up to the Supreme Court, made the argument, and they basically said, "Look, it's not our job to fix this stupid law. I mean, you've pointed out logical inconsistencies, but we cannot change the law. Our job is to interpret how it applies." Now, it just so happens that our Supreme Court's terrible and full of haters, but it's still a difficult argument to make that they need to read into the law what is not there already. And so the punchline to the whole thing was go to the legislature. Well, in Montana, that basically means you lose. Sorry, kid. So it was a very difficult place to be in Montana, and it was the same sort of thing where you're arguing on, look at this definition here, look at this other definition over here, think of what the spirit of the intent of the voters was, and their answer on that was, well, if we can't take a poll of the voters back in 2004, we have to look at the law that they adopted and assume that the way that it's written is what they wanted. So it's a hard argument to make that, well, no, let's talk, because I'll bet you they wanted something different. So it was a really, really frustrating experience, and I just think that your best bet really is to go in and change the language of the act and get past it.
Let me ask you this final question, and then we're going to let you go. But there were cases that went to your Supreme Court. There was the first one, which I'm sure you remember, and then the second one. It addressed some other issue, and some third one. Was it right out of the gate? And then before they got there at the lower court, appellate courts, there may have been, certain opinions. I'm talking the playing ground in the first year or two or three that set the stage of how the law was going to be interpreted. Law enforcement in the ambiguous areas. Was each of the Supreme Court rulings that came down on significant issues all adverse to the medical cannabis community, or was there some, like a couple steps in one direction, then some devastating opinion, or were they consistently bad?
It started out good, and everybody had hope, and then it went entirely bad after that. So the first case was, we had a probation officer deny a probationer access to medical marijuana because it violated federal law, and part of the job description of probation officers was to make sure people were in compliance with local, state, and federal law. So that went up to the Supreme Court, and the Supreme Court basically said, look, as a state employee, your job is not to enforce federal law. So if the state says this is medicine, it's medicine. And as far as we're concerned, as the Supreme Court, we're going to treat it like we treat any prescription. So everybody was really excited about that opinion, because it was like, yes, that's the way it ought to be.
Right.
Well, what happened was county attorneys were very, very gun-shy in pressing cases. They did not want bad precedent. They didn't, because we had, in Montana, we didn't call it the Section 8 defense because it wasn't Section 8. We called it the affirmative defense. Same thing. And they were scared to death of the affirmative defense because you've really got one set of standards in the main part of the law as to, like, quantities you can have in possession, the purpose to which it's put, and what you got to do to be credentialed as a patient or a caregiver. All fairly clear. But then when you get into the affirmative defense section, it's more about an amount reasonably necessary to ensure an uninterrupted supply. Well, that's not an ounce. That's some other amount, You're not talking about being in the registry anymore. It's about having a qualifying condition. So the standards were different under the affirmative defense. Law enforcement and county attorneys hated it. And they didn't want bad case law from their perspective. So there were not cases being pushed until we got into 2010 and 2011, when it was clear that the legislature was more inclined to ditch the law. And so law enforcement got emboldened. Well, all these cases take a while to get up to the Supreme Court. So it was in 2012 that we had a string of 4 cases come down, and they were all of them bad, every single one of them. And one of them was this issue of cannabis oil. And our Supreme Court came up with the exact same issue, really on the same reasoning as the appellate court in Michigan. Said, look at the definition of usable marijuana, look at the definition of marijuana in the criminal code. These two things are not the same. And we don't see anything that talks about extract.
That is so twisted that they had to have gotten it from somebody else, the Michigan judges. That's so they had to have pulled it out of. I don't think the most sadistic person.
Montana,
right, that's
apparently.
what I'm saying. Like, that's the kind of stuff that because it's just way off. All right, listen, I could, like I said, we're gonna have to have you back on, Chris. It's been fascinating.
Really great stuff.
Good call.
I didn't even talk about how I got busted. I ended up with 8 charges from the federal government, facing a mandatory minimum of 85 years. So didn't even get to talk about that. So yeah, please have me back on. It's been great. I really like chatting with you guys.
We'll definitely want to hear about
Jamie Lowe will be contacting you shortly. Thank you very much, everybody. Give a big thank you to Chris Lindsey, the Marijuana Policy Project's Michigan's liaison from Montana, wearing a suede jacket with fruffles on it. Is that right?
Fringe, the buckskin with fringe.
Cowboy boots, that's what I'm thinking. All right. Nice talking to Chris. Have a great night, and we'll talk to you soon.
All right, take care, guys. Have a good one.